Imagine hurtful words have been spread about you, perhaps impacting your professional reputation or career prospects. You feel a strong urgency to address these falsehoods, to clear your name and protect your standing. But as time passes, a nagging question might arise: is it simply too late to take legal action? In most cases, you cannot sue for defamation after the legal deadline, known as the Statute of Limitations, has expired. This deadline is a critical legal barrier, meaning that once this specific time period passes, your right to bring a lawsuit is generally lost, regardless of the merits of your claim. The statute of limitations for defamation is typically quite short, often just 1 year from the date the defamatory statement was first published. This strict timeline exists to ensure that lawsuits are filed while evidence is still fresh and memories are clear, preventing endless legal uncertainty. While this is the general rule, some jurisdictions recognize a discovery rule. This means the clock might start ticking when you reasonably discovered the defamation, not necessarily when it first occurred. However, this is an exception and not a guarantee, highlighting the nuanced nature of these claims. If you believe you have been defamed, acting quickly is paramount. First, document everything meticulously. This includes the specific statements, exactly where and when they were made, who heard or saw them, and any tangible evidence of the harm you have suffered, such as lost opportunities or verifiable financial damage. Next, and most importantly, consult with a legal professional experienced in defamation law immediately. They can help you determine the precise statute of limitations in your state and assess if any exceptions, like the discovery rule, might apply to your unique situation. This early consultation can make all the difference in preserving your legal options. It is also important to understand specific legal concepts that impact these deadlines. For instance, the single publication rule states that a defamatory statement published in a mass medium, like a book, newspaper, or a website article, typically has only one publication date for the purpose of the statute of limitations. This remains true regardless of how many times the content is accessed or viewed later. Another complex but important concept is equitable estoppel, where a defendant might be prevented from using the statute of limitations as a defense if their actions, such as deliberately concealing the defamation, unfairly delayed the plaintiff from filing the lawsuit. These specific legal doctrines highlight the significant complexity involved in defamation cases. Navigating defamation claims requires swift action and a clear understanding of legal deadlines. By understanding the statute of limitations and acting decisively to seek expert legal advice, you proactively protect your professional reputation and ensure your rights are preserved. Taking this proactive approach helps secure your peace of mind and uphold your standing in a challenging situation.